everyone. Welcome back to another FLP webinar, and this is the last one of 2023, and we're wrapping up this year with some of the ASP team tonight. John and Mike are with us tonight, bringing a lot of experience over this month's webinar topic and also FLP benefits. They'll be sharing their knowledge and real-world experience with examples and experiences on expert witnesses and investigators. As always, make sure to submit any questions you have in the comment section, and this webinar is recorded, so you can watch or share this webinar at a later time. Thank you all for joining in this month's webinar. All right, John, want to take it?
Yeah, you bet. I got it. Thanks so much, Ariana. Hi, everybody. I'm John Correa from Active Self-Protection, and with me, my favorite former Fed, Mike Williver. Dude, how you doing tonight?
I'm doing really good. I'm excited to be here, and hopefully we can all learn a lot. John is our resident expert on a lot of things, and this is more his wheelhouse than mine, but I'm happy to be here and fill in any blanks I can fill in.
Well, and so this is funny because, you know, Mike, we're going to talk about private investigators, and you were for a long time a public investigator.
Yes, I was a senior special agent with Homeland Security. I did 25 years as a federal agent, most of that as an investigator. So I investigated kind of unusual stuff. Our lane was mainly import-export. So anything or anyone coming in or out of the United States was our nexus for an investigation. So I investigated street gangs, international narcotics cartels, alien smuggling, sex trafficking, a whole bunch of other stuff. But most of my time was spent doing more field work on task forces. So I was more of the street cop of the federal world, as it were, and I relished that role.
So, but know the investigation side too, right? I mean, obviously,
Yes.
that role is really important. So if you guys don't know me, you haven't interacted with me much. First of all, how dare you? Second of all, my name's John. I founded Active Self-Protection in 2011. We run the largest YouTube channel in the world related to self-defense by views. We got about 1.5 billion channel views. Founded the company in 2011. I am a firearms instructor and a training junkie. I love taking gun school class. I'm a martial artist as well. Got 16 years of experience in martial arts. I'm also the very first Force Science Institute certified force science analyst as a non-sworn person. So they generally let cops do that. I was the first non-sworn they let do it. I'm a Masada Group certified deadly force instructor, a couple other things like that. I teach for a living, man. This is what I do and what my bailiwick is. And Mike joins me on that every week as well, is we break down real life incidents of violence for people to learn from. So we do that via video on the YouTube channel every single day of the week. 2 badge cams a week right now, Mike and I do together, and then 5 private citizen videos a week, surveillance footage. There's about 3,000 of those on our YouTube channel, give or take. And to get those, we've analyzed 50,000 defensive encounters for evidence basis for them. So we're talking tonight about expert witnesses and private investigators. And these folks show up in cases, well, in criminal cases, they show up where somebody's facing charges, and almost always hired by the defense in that case, because of course, in criminal cases, the prosecution's probably not using private investigators; they are using the police. So the detectives and investigations will do those investigations, right? And so, but in the private side, well, you might need an investigator, and you certainly might need an expert. So I've been doing expert witness work now for, gosh, Mike, I want to think probably around 3 years. You think that I've been taking expert witness cases? Something I'd have to dig back through.
Yeah, that sounds about right. Some really interesting ones too, by the way. Not for nothing.
Yeah, I mean, well, I got to be honest with you. When I got into this, I thought it would be, I just get to explain these cut and dried cases. No, what the reality is that when they call me as an expert for expert witness consultation and for actually writing reports and those things, they're a mess. They're always a mess. They always have some stank on them, and that's why I'm the one that's getting called, because they got to explain some things to a jury, and why would this be okay, and explain it to the prosecutor, explain it to the judge, explain it to the jury if we need to. So I seldom get invited to the ones that are like, oh, this one's cut and dried all day, every day, right. And because usually, I mean, here's the reality, okay? In most cases of defensive use of deadly force or the use of deadly force, it's pretty cut and dried, okay? Most cases of deadly force, Mike, I think you probably agree with me on this. Either it's, man, that was very clearly justified conduct, or it was very clearly not justified conduct, right? And
Yeah, I think that's true, John, as it relates to people who know what they're looking at. But you can tell from every time we're on a YouTube video that we see things the way we see them because of our experience and our knowledge. We will have half of our audience tell us that we're completely full of beans and don't know what we're talking about. This was obviously justified, and we're trying to explain to them, no, it wasn't. And you're going to be in a lot of trouble if you do this yourself. So we're trying to warn people, to warn them off and caution them to not do the things we're showing, even though it might be a feel good thing where we're sick of this crime and we're gonna do what we're gonna do. And it's funny how obvious a thing can be to us and not so much to the general public.
yeah, so that's true. I'm going to definitely give you that. So certainly, I would love for you guys to ask us questions. We have a few people who have pre-submitted questions about what are you wondering about expert witnesses or private investigators. I'm going to go through a couple of slides here just so you know what we do, what I do as an expert witness. Like I said, I've been taking these cases for a while. We can talk about what qualifies somebody. We're going to talk about what the ethical standards of an expert witness, when you might need one, and then how much they cost. And I'll get there when I get there. And Mike, same thing. We'll talk about that with private investigators. So let's talk about, for an expert witness, what makes somebody an expert witness. And there's actually here some federal rules of evidence that come into this play. So the federal rules of evidence 702 to 706 deal with expert witness testimony. So if you go look, if you want to actually have some scintillating bedtime reading, the federal rules of evidence will just give you hours upon hours of scintillating understanding of all the rules of evidence. And there's bunches of them. Okay. So, but in 702 to 706, it deals with expert testimony. And in particular, 702 is the one that I've got up here for you to see. And it says a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not. Okay, I'm just going to stop there. Okay, so I'm going to explain. Let me explain. No, it's too much. Let me sum up. So let me sum up. So an expert can testify. Now, usually the only people who can testify in court are witnesses, right? That they saw something, that they heard something, they had knowledge of the case directly because they were there. They're a material witness. An expert witness instead gathers data from all kinds of other sources. And then you notice here a couple things. They may testify in the form of an opinion or otherwise. They're literally the only person who can give an opinion in court. Everyone else is not allowed to give an opinion. And if they try to give an opinion, well, it was my opinion that, objection, that's speculation, they're giving an opinion. And the judge will say, no, that's not, you're not allowed to do that. But the expert, once they're vetted and they have been admitted as expert, they can give opinions as long as those opinions are within the scope of what they're talking about. How does an expert witness get qualified? You see here the very first line, a witness who is qualified as an expert in one of several ways: knowledge, skill, experience, training, or education. That's a very broad thing. And there's a lot of judicial discretion here as to whether somebody is qualified by one of those things. So it's not necessarily, in what I do, for instance, qualification as an expert in firearms or as an expert in self-defense. There's really not a college degree in self-defense. So you have to have some knowledge that is beyond what people would expect, and it has to be gained by some other way. How'd you get that knowledge? How'd you get that skill? Well, you gained it by experience, by training, by education. So you do things like showcase your curriculum vitae, your resume that says, here's all the things that I've done. And so you got to say, wait a minute, I am qualified in the area that this person wants me to testify in front of the jury in. So that's where it happens. So an expert can get qualified, and honestly, it's a fairly low bar. Somebody who's an NRA certified firearms instructor could quite conceivably get admitted to court as an expert in firearms training because they do things that it is their knowledge is beyond what we would expect a general member of the public to have. So if the court believes beyond kind of a preponderance of the evidence, if it's more likely than not that expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. So the trier of fact is either the judge in a bench trial or the jury in a jury trial. So if the judge believes that the expert's testimony will help the trier of fact to understand the evidence, well, that's a lot of times what an expert witness does. I always tell folks what it looks like is that an expert witness is not the umpire. And if we're looking at a baseball analogy, right? So the two people playing the game are the prosecutor and the defense, right? And they're the pitcher and the batter. I, as the expert witness, am not the umpire. That's the jury. That's the umpire. They determine, is this a ball or a strike? I teach the jury what's the size of the strike zone, what is a ball and what is a strike, and then they look at the facts and determine, well, was that fact inside the strike zone that I got taught or not? And then they make a determination if it was a ball or a strike. Second thing, though, the testimony has to be based on sufficient facts or data. So the expert has to disclose what information sources did you use in order to come to your conclusions. So when we write a report, we'll say, I looked at this, I looked at this, I looked at this, I looked at this disclosure, I read these reports, I watched these videos, I made these measurements, I did these tests, and that came to this thing. C, the testimony is the product of reliable principles and methods. In other words, the trier of fact is looking, did you come to your conclusions via the scientific method, really, a repeatable medium, that this is reasonable that you came to that because it's reliable. I mean, if you say, hey, we sacrificed the chicken and the entrails of the chicken told us that this was the case in this case, that's not a reliable means. And then number 4, the expert opinion reflects a reliable application of the principles and methods to the facts of the case. So you have to explain yourself. Because of this evidence, I take this particular position on this. Because of this evidence, we take this understanding of this, and therefore, in my opinion, this is the case in these places. So at the end of things, how is an expert witness qualified? Well, what it is they are looking at the facts at hand, so say the charges in a criminal case, right? And if we're going to be talking in a criminal case about the use of force, well, is this expert qualified to talk about the use of force? Well, things in my world, like I am certified as a Mossad AU Group certified deadly force instructor. So I understand the law very, very well at a much higher level than most people, frankly, at a much higher level than most attorneys. I teach attorneys this stuff all the time, and I'd say that from the stand. Number 2, you say, oh, okay, I'm a Force Science Institute certified force science analyst, so I understand human performance as it relates to the use of deadly force. So we'd explain that. Here's where I have knowledge that the average person doesn't have, and here's how I apply that knowledge and reliable principles for the interpretation of data to the data at hand, and therefore come to reasonable conclusions. And those being the case, okay, you're qualified as an expert witness. Now, normally, an attorney is not going to put somebody forward as expert that they're really worried won't get qualified by the court as an expert. They're looking for somebody who is kind of a no-brainer. Yeah, this person is an expert and can help us. I tell folks all the time, I'm not worried about when I hand my CV to a judge, or I email it to the attorney discloses it to the court. I'm not worried about a judge looking at my resume and going, I don't know if this guy can help us. I don't know if this guy's good enough. Let's go find somebody else. Mike, have you ever had anybody run across that in all the trials you dealt with?
Well, I was actually going to mention the government does from time to time employ expert witnesses for things that are sort of outside the scope of law enforcement. So in a lot of our trials, for example, there would be a vehicle and there was some drugs, some narcotics that were being trafficked that were concealed within the vehicle, the rocker panels, or a natural void in the vehicle, or a compartment, or whatever. And in order to get that evidence explained to the jury, they would bring in this one guy that was in a lot of these trials was just an auto mechanic. He ran a tow yard and he was an auto mechanic. And he could explain to the jury things like, in these rocker panels, which is the area between the two wheel wells, on the bottom of the car, there's a natural void, blah, 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 blah. Or he could explain why the compartment that was constructed by the cartel, for example, was not original equipment, how it would affect the way the car handled, all that sort of thing. But I have seen more than once in a federal criminal trial where an expert witness was not accepted. It was usually on the defense side, but the judge was like, nope, it just said no. And that's something you got to bear in mind. If you're hiring an expert witness, I wouldn't hire anyone doing it for the first time, because that person could get tossed potentially by the judge, and you don't want that.
Now, of course, everybody has to go for the first time one time, right? But
Not on my trial, they don't.
Not on my trial. There it is. Not on my trial. Heck no. And you know, at some point they're going to be the first. But I would say this: make sure that whoever it is that you are hiring is highly qualified. Is because if they get tossed, well, then all that work that they did for you, all the report. So when the expert discloses their opinion in a written format, okay, we call that an expert witness disclosure and an expert witness report. And that expert witness report, once you're accepted as an expert, that report goes to the jury. The jury gets to see that report. And so it's and they get to see that in their deliberations. So it is a powerful document. Has to be put together correctly. There are rules for putting it together. There's things that can be in it, things that can't. And I agree with you, Mike. I mean, I've worked one case for an assistant U.S. attorney out of Florida. I worked for an assistant U.S. attorney out for a little bit out of Chicago on a consulting basis. And so I've worked for the feds, and I will be honest with you, every time I work for the feds, it reminds me why I don't work for the feds. That's just the reality of things.
I don't miss it personally. I much prefer working at Active Self-Protection. That gives you an indication of what it's like dealing with the federal legal system. It's a mess.
All right, let's look real quick. I want to talk about, so that's the qualifications. You want to really highly qualified. I want to also talk about the ethics, and we want to push through this. I don't want to belabor the points here. So an expert witness has some rules associated with who they are. First of all, the American Bar Association has a rule 3.4, relating to the fairness to the opposition. And also those federal rules of evidence 702 to 706 also deal with the ethics of an expert witness. And there's a couple things that you got to be really aware of here. First of all, it's okay for any witness if an attorney needs to pay that witness's travel and expenses and lodging and food or something, because they, listen, if you want me to come and testify. But a material witness cannot be compensated otherwise for their testimony. An expert can. Because again, I'm not a material witness. So if you want me to stop doing my regular job and do this job for you, it's reasonable and ethical for you to pay me. However, they cannot be paid on contingency, right? In other words, depending on the outcome. So if you write a report and it gets us acquitted on these charges, then you'll get paid X amount versus you'll get paid Y amount if we get convicted. That's unethical, because what that does is that puts pressure on the expert witness to give you conclusions, okay? And that's the next point. They can't be coerced in their opinion or asked to give a false opinion or an opinion from only partial data. They must be able to give a full and complete answer. And I always explain this to attorneys when they hire me or when they talk to me about being hired, that say, hey, man, listen, I will give you my earnest and honest opinion, and I will give you a full and complete understanding of what I see of the evidence you present to me in disclosure. And if your baby is ugly, I'm going to tell you your baby is ugly. And if you have problems here and you should take a plea agreement, I'm going to tell you that. And that will be in my disclosure. And that's, first of all, it's in my initial disclosure to the attorney, and it's in my contract with them that says, here's my retainer, here's what I'm being paid to do. And you cannot pay me more or less on a contingency or for my opinion. And you must disclose to me all relevant information so that I can give a full and complete opinion based on the totality of the facts available to me. And I think sometimes it amazes me, Mike, how many times I have to explain that to attorneys.
Yeah, I won't name any names, but there was more than one occasion where doing trial prep for a federal case, when an assistant U.S. attorney was, not saying it out loud, but basically kind of wink, wink, nudge, nudge, can we fudge this or fudge that? And the answer, of course, is no. I like my job. And as John said during our pre-brief, I like my job and I like my freedom. I don't want to be in federal prison for lying under oath. So there are occasionally shenanigans that go on. Anyone who hires John Correa and tries some shenanigans is not going to get very far, because John has more integrity than most people I know. So that's not a problem there.
I've never had to do it, but if, to tell an attorney, hey, I quit because you're doing shady stuff. And then guess what? It would then be on me to tell the court that. I've resigned from this case, and after I disclosure, obviously, I've resigned from this case because I believe that there is unethical behavior going on. Hey, man, if you want to do that, go away. Go ahead. The next part of this, the expert witness actually works for the finder of fact. So this is another thing I always tell and remind, they should know this. Again, Expert witness work is kind of a higher level, like elective class in law school, and many of them don't have a lot of extra, continuing legal education on this. Some, but I work for the finder of fact. So as the expert witness, I work for the jury or for the judge. And I tell folks I work in stages. So the first job that I have is to educate the attorney that hired me on the issues and look through those issues to give them some understanding of them. Then I write a report that educates the judge and the opposing attorney. And oftentimes in a criminal case, if I'm hired by the defense, then the prosecutor, right? I'm trying to give the prosecutor a whole bunch of info because my hope is the prosecutor looks at that disclosure and goes, I'm not going to win this one, and dumps it, right? Or at the very least goes, I'm going to probably lose this one. And then if we get to trial, then I get to educate the jury. And if I don't want to push too hard here, but if you go in the Ask Unlimited app, we have our own family of apps. Firearms Legal Protection is a sponsor of the app. We have a full case that I did, and if you go watch this, you go watch the case. The agent, the agent of the ATF, he's a VAFI agent who was the expert for the prosecution. He talked to the prosecutor the whole time. I, on the other hand, talked to the jury the whole time. And said, hey, ladies and gentlemen of the jury, I work for you. And so my job is to be here to help you. So the attorney would ask me a question. I'd listen to the question, then I'd turn to the jury and talk to the jury, and then come back here and listen to a question, and then go talk to the jury, because that's who I work for. And they have to give a full and fair opinion, So as the defendant, you do not have to give any tools to the prosecution. You don't have to disclose, hey, you know what? I buried some evidence in the backyard. But you shouldn't do that, by the way. That's destruction of evidence is bad. But you don't have to hand them any victories. But anything that's disclosed to me that I use in my investigation, I have to give a full and fair opinion on that. And I will give a full and fair opinion on that. And the big one there at the bottom is that an expert witness has to stay in their lane. Now, what I mean by that, I've been admitted, I'm court admitted in firearms, I'm court disclosed in use of force and in police training. And you might say, oh, okay, John is an expert in firearms. I am. I'm a court admitted expert in firearms. But wait a minute now, there's some aspects of firearms that so let's talk about the design flaws inherent in this safety system. I would look at that and go, okay, time out. I am by far an expert compared to the general public in firearms. Once we start talking about gunsmithing, we've stepped just a skosh outside my lane into a place that I'm going to suggest you get somebody else, because I don't want to give you any more than I have. So they have to testify to their experience and their good stuff. Because, for instance, a doctor is an expert in medicine, right? But they may not be an expert in this particular laser treatment for cancer. And that may be outside their lane as a podiatrist or something like that. You get my point, right? So let's think about that. That's the ethics. And again, I've already talked about this one. I don't have to belabor it. Let's talk about our role. I always act first as a consultant to the lawyers, tell him if his baby's ugly or her that her case is great. I prepare a report from data that's given to me. That gives me, it states my qualifications, the facts that are given to me, what was considered in this, the standards of those, the interpretation of those facts. This is disclosed to the court. And so that report, once it's executed, it'll bounce back and forth, because what'll happen is I will send the attorney a report that says, hey, here's what I've said so far. And then a lot of times the attorney will come back and say, John, do you have an opinion on this piece? Do you have an opinion on that thing? Now, they won't say, hey, John, do you think this was okay? That would be leading me. Instead, John, do you have an opinion on this issue? I do have an opinion on that issue. Tappity, tappity, tap. Let me add that in. Let me do that stuff because you're looking for that. Great. And then once they're satisfied that it is a good report and it's a full and complete report that they're looking for, they disclose that to the court, disclose me as an expert to the other side. Now, if I get disclosed as a witness, then you have to be admitted in court through what they call voir dire. Voir dire means to speak the truth. It's the same thing that about choosing jurors, right? So voir dire is the process they use to choose jurors. So you might have a juror pool of 24. Out of that, you get 12 that you actually have on the case with a couple of alternates. I will go on the stand and have voir dire. So, Mr. Correa, tell me about your experience. Tell me about your background. Tell me about your education. Tell me about these things. And do you do that stuff? and here's all your background and why you're qualified in there. And then at some point, your attorney will say, Your Honor, I motion that that Mr. Correa's testimony be admitted as expert. The other side can object. They can cross-examine. They can try to impeach you. And then at some point, the judge either says, admitted, the jury will consider this witness's testimony as expert, or ejected. Not, they won't use that word. It'd be kind of neat if they had a hand with like a button.
The floor drops out from under the witness box.
Right. That'd be cool. And once admitted, an expert is the only person that can give their opinion to the judge. They can be asked their opinion and they're allowed to give it. The other part of that is the expert, and I've done this in open court, is lawyers are kind of really good at trying to pare people down and only answer like yes or no to a question, and only like hammer down this tiny thing. But as an admitted expert, it's really easy, and I've done it, to look at the judge and say, Your Honor, I believe that so that the jury can understand, I need to answer more fully than yes or no. May I please? And the judge will say, absolutely, please answer a full and complete answer. That's your role here. And then I will answer a full and complete answer. So if you're good at your job, and I'm telling you, there's a difference even between an expert that writes a good report and an expert who's good on the stand. Somebody who's able to connect with people, who's a good communicator, who knows how to think on their feet well, who knows how to answer questions, and also can see through the sometimes voluminous horse hockey. Is that okay to say, Mike, that there's horse hockey in court?
Yeah, I have some personal experience with that, having testified in a lot of cases, state and fed. And I got to tell you, one of the tactics an attorney will employ is sort of leading you down this yes or no primrose path to where they want you to end up, and being able to look 4 questions ahead and realize what's happening is critical to being an expert witness. Not something you necessarily are going to be good at. You could prepare a great report, but getting in court and being under the sort of the hot lights, John can tell you what it's like. It's a little nerve-wracking, because you're extremely cognizant of what you're saying. A criminal trial is more a carefully scripted word game, than it is any kind of search for justice and truth. And so the ability to appear relaxed, communicate with the jury, which was how I did it as well, and just be relatable, and sort of friendly and affable is probably almost more important than the material you're presenting. Because if the jury looks at the witness and is like, I don't like that guy, you know what I mean? I don't like the way he talks, I don't like his attitude or whatever, then it doesn't, I hate to say it, it doesn't really matter what you say. If they don't like you, if they think that you're a jerk or you're pushy or you're overbearing, that's going to affect how the jury views your testimony. That's just how.
Or you're boring, or you are, unrelatable, or you're a huge nerd. I mean, so that's the bottom piece here. The jury does not have to listen to you as an expert witness. That jury doesn't have to listen to any witness. Witness testimony is weighed by the jury and given weight according to whether it makes sense, and they find the expert credible. In the case that I testified in court in June, I testified for the defense, and an agent of the ATF testified for the prosecution. The jury acquitted on that charge. And so at some level, the jury trusted my testimony at some level above the agents. And if you go watch it, I think some of that was relatability, and the ability to kind of explain positions here. Also, the fact that the agent said that he didn't understand Michigan law and didn't need to in Michigan court was not helpful for his cause. Mm-mm. I wish him well. So that's what an expert witness will do for you. Let's talk about costs, not shying away from that. Obviously, these vary by expertise and experience. When it's his first time doing it and he's an NRA certified firearms instructor that you're trying to get admitted as an expert, you probably get away with that guy pretty cheap. I will tell you that they can go huge from there. So there's usually a retainer to begin. I just accepted a case this week, in fact, and my general retainer is 10 hours of fees before I'll start working. So, which is refundable if we don't use them all. But if you send me a pile of discovery, guess what? It's going to take me 10 hours to read through your pile of discovery. So it's usually an hourly rate for prep work. So to read through discovery, to write reports, to be on the phone with attorneys, to talk with the client. there's usually a day rate for depositions and for trial days. Now, that includes expenses for travel, right? So I always tell folks that you should expect your expert witness that if they have to travel, the travel days count as full days and trial days. So if I have to testify on Thursday, but I got to fly in on Wednesday because I got to be available all day for the court, well, then Wednesday counts and you got to pay me the same day rate for Wednesday that you did for Thursday. And then I fly home on Friday because I have to be available until 5 or 6 p.m. to the court and I can't get a flight home that night. Well, then guess what? You got to pay for all 3 days. And I'm sorry for that, but that is what it is. And you just have to. The hourly rate can be anywhere. I mean, I've seen as low as $175 for an expert witness in our world in firearms and self-defense. I would say I wouldn't hire somebody who's charging $175. Quite frankly, that to me scares the dickens out of me. I've seen upwards of $1,000. I will tell you, if you want to hire Masada Ayub to be your expert, pay that man his money. Okay, you're gonna end up paying him some money, depending on who it is. And a day rate is usually either an 8 or a 10-hour day, depending on who does it, right? So if you charge $200 an hour, you should expect a day rate of anywhere from $1,600 to $2,000 is pretty typical, and it can vary from there. And I will say, can you negotiate if you had to hire an expert witness and you're like, hey, can we negotiate those rates? I mean, if you want to. Remember, they're doing important work for you. Usually, if you trust them, pay them. That would be my thing. Same thing with your attorney, right? If your attorney, you look at it and go, well, can we negotiate that a little bit? I mean, you can, but we're starting off. We've now stopped being friends, and now we're going to be adversaries for a little while to figure out how we're going to work together. So I wouldn't do that. Now, I will say, Firearms Legal Protection does have both of their premium individual plan and their premium family plan covers up to $10,000 of expert witness expenses if they're needed. And if their lawyer determines that an expert witness will help and they apply for that benefit, Firearms Legal Protection will cover up to $10,000 of that. And listen, I will say that if we get through the report writing stage, that should cover most things, honestly. It should cover a lot. If you get to trial, you might need to pony up some. Depends on who you hire. But I've done court cases where it's exceeded that. And you expect everything when it gets to court to be expensive. Okay. So now, obviously, Mike, when you're doing trial stuff, when you were working for Uncle Sugar, that's just part of your job, right?
Yeah, trial prep is it's one of the things you don't see on the Law and Order or the CSI shows. Is the hours you spend in a room with the prosecuting attorney and their team and other investigators, and occasionally debriefing the defendant. It's all very dry stuff, but trial prep is a very big deal. A lot of it has to do with what I was talking about earlier. If you've never gone to a criminal court case or been a juror, actually scratch that. If you have time one day, go down to your local courthouse and sit in on a criminal trial for half a day. And what you will notice is occasionally the jury will be excused for whatever reason so they can discuss things. And the things they're discussing are almost always about how they have to tiptoe through the facts of the case to not bring this or that thing up. There's so many moving parts in a criminal trial. So the trial prep phase is long and arduous, and it's really to try to minimize the amount of time spent. Try not to waste a jury's time or a judge's time with stuff that we could have thought of ahead of time.
Well, and try not to blow a jury up, right? I mean, if you have to go all the way through voir dire again, and because you said something stupid, and all of a sudden you hit a mistrial, which happens, you hate that. You don't want to do that.
Yeah, just a quick story. We had one of these border bust narcotic cases, and during trial prep, we go back and we have to talk to all the law enforcement officers that were involved in the case, and kind of find out where they're at and make sure they can make it to court to testify in the trial if it's going to trial. And in this particular case, the Customs and Border Protection officer that had discovered the dope in the car, that was cocaine, liquid meth, I think, a whole bunch of it, kilos of it. That the actual arrest had been 2 years prior. The trial is, it takes a long time to get to trial. By the time we get to trial, we contact that guy. He had been investigated, arrested, and convicted of corruption charges in the interim for basically taking money from cartels to wave dope and human cargo through. And so if you can imagine, we almost had to drop the case, but instead we took our lumps and got this guy out of his parents' basement and got him in there and had him testify. And yes, the defense had an absolute field day with it, but it's just one of those things. You're like, oh, we're going to trial. This seems open and shut, and then something which that case would have otherwise been, and instead you get thrown the sort of a wild curveball. But you just never know. And I would definitely do your research. We're talking about expert witnesses now. Still, I would do your research independently. If your attorney is hiring someone, I mean, at least do a basic Google search and just make sure there's nothing glaring about this
No
person.
big
Google
stink
search
under the covers there.
Yeah, exactly. Yeah, you don't want to find that out in the middle of a trial. That can
Now,
be very bad for you.
I would also say at the same time, I have never had a client email me apart from their attorney that ended up being remotely good. Like it was always bad. Okay, so you want your attorney to have a great relationship with your expert witness, and usually they have the connections to find a good one. Now you might say, "Hey, I really like this guy, and so can you email him or whatever?" And they might, that might be a good thing. Or he might be like, "Hey, I've got a really good relationship with this guy. I know he's really good. He really works well in court, and we work well together. Okay, what's his name? I'm going to be paying for it. So this case that I just recently took, it's here in Phoenix, and talk with the attorney. The attorney sent me a little bit of stuff. I looked through it. Okay, I think you might have a case here. I can't guarantee you until I see everything, but I'm willing to do that work for you and give you an opinion. Okay, let me talk to my client. You bet. Send him my CV and you can have him look me up. And came back a couple days later. My client thought about it. He'd like to hire you. Okay, cool. And then we figured that stuff out. But again, I wanted him to think about it. Let's talk real briefly about private investigators. All right, real briefly. A PI. 40 states require a license for a private investigator, which means in 10 states they don't care. Which
is nuts. That is so crazy to me that you can have someone take that job and just off the street, like no qualifications potentially.
Both willy and nilly, as they say, right? Just shenanigans abound. A private investigator is definitionally a private citizen, right? So this is not a cop. This is not somebody who is a cop off doing cop things. Cops have investigators too, right? Usually called detectives. They are detecting, right? Investigating, those things. So a private investigator is a private citizen with the rights and privileges of a private citizen. They cannot ignore the law, and they have no statutory power, and they cannot impersonate a law enforcement officer, right? So they might get a little badge case that says private investigator, but you got to be real careful that don't look like a cop shield, because you start going whoosh like this and showing what might look like a badge to people, you can get in big, fat, ugly trouble. I'm not saying I have a case right now where a dude went, look, I'm a private investigator, and gave the impression that he was a cop, but that makes you look really bad when that stuff goes down. Now in Arizona, Mike and I both live in Arizona. It's a very low qualification. A high school diploma, you have to be 21 years old, pass a background check, and pay them money. And ta-da, you're licensed as a private investigator. Now there are different levels of qualifications from there, and different certifications that private organizations do, and state level organizations, and there are guilds and stuff like that for the organization. But to get a license, very, very low qualification. You don't have to have a lot of training here. But what do? Well, I mean, these folks go find stuff that's not easy for the general public to find. And so you might need different private investigators who are really good with computer stuff. We need to know, where this guy's phone was all these times. Well, I don't have access to some of this stuff, but he had his Google location services on, and somebody shared that with him, and so I can track it via that. All right, cool. And maybe that stuff. They conduct interviews. They do, internet searches and record searches. They go down to City Hall and look through public records. They gather and analyze evidence. They write reports. They conduct surveillance. The classic thing that you're kind of used to on the movies of the guy sitting there with the camera watching somebody and clickety, 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 click. That's a private investigator is doing that work, right? They're locating assets or people. So we see private investigators hired all the time to repossess cars. Hey man, this guy's car, he hasn't paid his loan. Cool, I'll go find that car for you. And then when we find it, then we hire a repo man to go pick it up, or whatever the case may be. Or people too. We're trying to find where this person is. All right, well, let's see if I can find him. Let's see if I can find any public records, and so that's what they're doing. They are looking for something. They find stuff that's not easy for the general public to find. So, what these people aren't is you're never going to, they might be called as a material witness in a trial because they might see something. right? They might know something. Hey, we went looking for this person. Yes, in my investigation, I found this. And I found this piece of evidence. Well, once we have that evidence, now that would be disclosed to the other side. They'd admit it as evidence. It would get, vetted as evidence and then admitted into the court. So they might get called to testify, but that's not their primary role. Their primary role is to unearth all the thing and analyze and gather evidence for the attorneys to then present in court. And hey, if they go find it, they may end up having to talk about that and ended up coming into court. And this is what I investigated. This is what I found. And of course, that means that their resume is fair game too. And they can be impeached. Like, what are you doing? So they want to be doing things. You want your private investigator to be above board. Yeah, you kind of watch sometimes, Mike, and it does crack me up. You watch things like The Lincoln Lawyer, and I love, lawyer shows and stuff like that. But you watch his private investigator doing like shady crap, doing stuff that you're like, bro, you're gonna get impeached doing trash like that. What are you doing? Get out of here, you loser. And
yeah,
and
100%.
So, as an investigator, your character matters. It's like that case you had, right? I mean, you're just gonna take some mad lumps if you don't.
Yeah, just to harken back to that story, just for a moment, because it's pretty funny actually. The Customs Border Protection, the disgraced officer gets on the stand, is sworn in, and the government attorney talks to him for a few minutes, asks some questions, very basic, and the defense attorney gets up there and says, "I'd like to, put this slide up on the screen," and it was the oath of office that every soldier, sailor, Marine, police officer takes. And he says, "You just took a sworn oath to tell the truth about 10 minutes ago, right?" He's like, "Yeah." So, "You remember this oath?" And he, the jury's looking at him. He's like, "Do you mean it when you swore to God about that oath? Did you mean it then? Do you mean it now? How is anyone supposed to believe anything you have to say?" I mean, we lobbed him an absolute softball to swing at with that. But hiring a private investigator, if you're going to do it for, let's say you're doing it, it doesn't involve a court case or whatever, you're just hiring one for whatever reason to follow someone around. You really have to do your homework, because there is everything from absolute goofballs who don't know what they're doing and do goofy stuff and break the law, or are completely incompetent, and then there's people who are very good at their job. A lot of times you get former federal agents, detectives who hang out a shingle when they retire, and they can be very good at their job, or people who've never done that job can be good at that job as well. But you want to do your homework and make sure you're getting the right thing. I did a little research for this webinar, and I live in Pima County in Tucson, Arizona, and I called the public defender's office and spoke with a very friendly lady there. And I said, "Do you have full-time defense investigators?" Because the defense attorney has an investigator frequently to run down leads and to verify stuff the police have said or whatever. And she said, "Yeah, we have full-time ones that are employees of the public defender's office, so they're essentially government employees as well. And then we'll hire out sometimes other investigators." And I said, "What is the hourly rate for those investigators?" And she said, $40 an hour. And it occurred to me that just like I don't want discount LASIK surgery or discount heart replacement surgery, I don't want someone making $40 an hour to be running down leads in my criminal case where my butt is on the line and I'm potentially looking at going to prison for a long period of time. I want the best that I can possibly afford. Now, I spoke with a bunch of other private investigator types who all had very good sort of reviews online. And the cheapest price I found hourly for them was $175. And that is in a 10-hour, I think he said an 8 or a 10-hour retainer. So you're up front, you're paying that amount. And that's the lowest cost one I could find. But that's, it's, again, you get what you pay for, and you don't want to scrimp on something as important as an investigator who's potentially going to find the thing that's going to get you found not guilty.
Mike said it all right there. Vary by experience and expertise. Depends on if they're freelance, they work for a bigger company, can be $40. You don't want the $40 one. 150 plus, super, super easy, it happens. And the same thing, the Firearms Legal Protection Platinum, the premium plans there, both the individual and the family plan covers up to $10,000 of private investigator work if that is necessary. So, well, friends, that's where we are. So, hey, this is what I get to do as an expert witness. I will tell you, I only take a couple cases a year. I don't like look them up by like, hey, am I going to win this one? Because I don't know what a jury's going to say, and I don't even know where it's going to go. I kind of look at them. Does it have merit? Can I actually help? Is this a case I can really help with? Does it, is it going to work in the schedule? Because sometimes the answer to that is just no. Like, what are you expecting and when? Well, we go to trial in 3 weeks. I'm sorry, I have an event booked in 3 weeks. I can't help you. Now, that's very rare, but I did have a case where I had a very short throw and like, hey, we're going to trial in 3 weeks and we need somebody right now for a weird reason. All right, there we go. So I only do a couple of them a year, and because I have my whole company to run, I have active self-protection that people expect me to put out videos every single day, and we go travel the country and teach live classes and those kinds of things. So the expert witness stuff, it's engaging mentally. I really like the mental portion of the work. It's delightful to help people and to be a part of good people staying out of jail, and but it's very time consuming. So yeah, I don't do a ton of it. So we had a couple questions come up.
Yes. Yep. I'll get to the Q&A in a moment, but thank you guys both again for joining this month's webinar. We know how valuable an expert witness and investigator are, but you guys really clarified why and what they really do to help cases. So I definitely appreciate that. And we're very glad to both have you on another FLP webinar to share your knowledge. But before we get to the Q&A, we have some pre-submitted questions. And there was, I think, only a couple that went through the comments. So if you guys have any more, make sure to submit them. I'm going to discuss what FLP has to offer you, which includes what we discussed tonight or what John and Mike did. I didn't do much talking, obviously, but the expert witness and investigator fees are, like John was saying, a premium benefit as an FLP member.
Firearms Legal Protection offers several different memberships to whoever is interested in signing up for legal protection. These plans are divided into individual plans and a family plan, which some benefits and pricing vary state by state. For the purposes of this webinar, we will look at our most common plans and benefits that are available in most states. The individual basic plan includes protection in your state of residence. It also includes uncapped payment of attorney fees for defense of criminal and civil cases. Firearms Legal Protection memberships also extend to all legal weapons, including non-lethal weapons. With the individual basic plan, you also have Defense of Extreme Risk Protection Orders, also known as red flag laws. All plans have access to the 24/7 emergency attorney answered hotline, so no matter a time an incident may occur, you can count on our hotline and an attorney will pick up for immediate attorney-client privileges. You also have access to the MyFLP mobile app and one of our recently added benefits, expungement of criminal record on non-conviction incidents. Members of all plans also receive access to digital content and special discounts. The next step up is the individual premium plan. This plan has nationwide coverage and also includes all the benefits just mentioned and payment of bail bond premium, payment of expert witness and investigator fees if either are needed in your case. There's also coordination of counseling support, payment of lost wages if you are out of work during trial, and a list of other benefits. We also have the family premium plan to choose from for those who want the same protection also applied to their family. For just a little bit more, you get all the benefits that were just mentioned applied to your spouse and all minor children. If you want more information over these benefits, then check out our Instagram or Facebook page for uploaded explained benefit videos. Remember, if you, friends, or family are not already protected by Firearms Legal Protection, please click the link below for a special discount we offer our webinar viewers. Now, let's get back to today's webinar.
All right, let's go through the pre-submitted questions first. I'll pop them up and then you guys can discuss. The first one, in the event of a DGU, should you alert the police of the location of your weapon to the dispatcher or when they arrive on the scene? Best to holster it or leave it on the ground near you?
Listen, in the event of a defensive gun use, you say, hey, somebody's been shot, they're going to pretty well know there's a firearm around, right? Big thing, if possible, as soon as you start seeing those reds and blues, you don't want to have a firearm in your hand. I don't care if you holster it. If you have a good holster that you can, the mouth stays open and you can safely, carefully, reluctantly holster, grease the landing, don't point a gun at yourself, awesome. Otherwise, just safely put it on the ground and you want to have your hands in the air for that. Now, if you've used it and let's say that whoever you had to use a gun has scrambled off into the wild blue yonder, okay, fine, they have broken contact or you've broke contact. can you tell the dispatcher, yeah, I've reholstered the gun, so I don't have a gun in my hand. All right, cool, fine, whatever. Or I just, I put it down on the table and he ran out of the house or whatever. Okay, fine. That's totally okay. The cop's going to assume you have a gun. And I don't think it's a bad thing to tell the dispatcher the gun is safe and is out of my hands, because they should relay that information to the responding officers, which should help them come in with less than, spidey senses tingling at level 10. Mike, what do you think?
Yeah, I would add to that. You should anticipate the police coming in hot and pointing guns at you and yelling. I mean, that's almost certainly going to happen. The reason for that being, they don't know who you are. They don't know what's happening yet. They have no idea what's gone on. So they just have to assume everyone's potentially a bad guy, including you. It's nothing personal, I assure you. And I would add to that, sometimes the dispatchers, and John and I have seen this on a bunch of the badge cams, where we listen to the dispatch call of the person calling 911, and then what they're saying and what the dispatcher is typing to the CAD unit and the officer's car aren't always exactly the same thing. So there could be a miscommunication. So just above all else, do not have a gun in your hand when the police arrive. Make sure your hands are clearly visible, open like this, and just do what they tell you to do. And, if they're rude, if they yell at you or whatever, don't take it personally. Hopefully when everything is said and done, they'll dust you off and apologize. Hopefully.
Great. All right. Next question. How do I find an expert witness and investigator for my legal proceedings if you don't have FLP?
Well, obviously, the beauty of having Firearms Legal Protection is that I'm a consulting expert for them. So their attorney network knows. They can email me and, hey, man, I need somebody to think about this. And I might not be the right guy. I might not, but I got a pretty big network, so I tend to help folks like that. Otherwise, how do you? Well, depends on what you need an expert in. There's actually websites you can go, if you just Google, how do I find an expert witness, they'll show up. But usually, hopefully, if your attorney is worth their salt, they've got a network already. They've got folks that they have used in the past and that they trust. Or if you've got stuff here, like, listen, if you're sitting here on this webinar, I do take a few of these cases a year. If you want to get, you're like, hey, I think Korea's got some good things to say and he can help. You can have him reach out to me. I think the last thing you want to be doing is, thumbing through the yellow pages, while you're trying to figure this stuff out. I think the same as an investigator, right? If your attorney has a bead on one already that they're used to and they're really good and they know that stuff, all right, I'd trust your attorney. Now, if your attorney says this guy's really good and you're like, dude, this guy's a total scumbag, you might need a new attorney.
Yeah, I was going to say the same thing. If your attorney doesn't have, for example, your attorney doesn't have any relationships with any investigators or expert witnesses, I would consider getting a different attorney. Obviously, I think, but yeah.
And it's a real pain to fire your attorney. But if if your attorney turns up an investigator that you're like, whoa, this guy's a 3-time felon and, has done all these bad things. And yet, but he's also your brother-in-law. Okay, we got problems. And your attorney is a dirtbag and needs to be, turned into their bar. So, yeah.
Yep. All right. Was there ever a case where you saw that there was a failure in the investigation?
Investigation.
I would guess that's investigation.
And process therein. Was the testimony pre or during trial definite to the outcome?
I've definitely seen cases where investigators created huge messes. Mike, you talked about that one that you had, right? That the investigator later was convicted of corruption charges. Oh, man, is that going to mess up a criminal case?
Yeah, I think something that's maybe not commonly known as well, outside of the legal or law enforcement community, is that prosecutors frequently just will not take cases that they're not almost certain they can win. So if you're going to trial on a case, that's not something that obviously has to be brought to trial. Like if someone doesn't plead guilty to murder, you got to go to trial. You got to go to trial with whatever poop sandwich of problems you have. You just have to take a bite of it and press on. Other cases, like again, I'll go back to my experience. Some of these border bus cases, they didn't have to. We didn't have to press on. We could drop charges if the case wasn't very good. And so frequently, if you're going to trial, that means the prosecutor almost certainly thinks they have a good case. They're going to win. And so if anything, were brought up pre-trial that would impeach a witness, or you have, like sometimes you'll have a a police officer or a detective who has some legal issues of their own, and that could cause them problems. They usually weed that out ahead of time, but it's not unheard of that during the trial there's something like this does come up. It's happened.
Yeah, and remember, failure in the investigation and the processes getting there, there can be failures in that, and that's, but remember, before the trial starts, the evidence that's being presented is already established, right? So it's pretty darn rare for either side to go, oh, hey, I have this new evidence. Like, I know you watch Netflix and in the Lincoln Lawyer, like, dum, 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 Your Honor, we need to be in chambers because we've got this new evidence that's this big thing. That happens, mistrial, start over, like, okay, cool. And we just declare a mistrial and we're going to start completely over because it changes things so big. So that stuff is usually well established. And if the defense can present exculpatory evidence, they call that. So evidence that proves innocence or shows non-guilt. And the prosecution is required to disclose any evidence of that's exculpatory as well. So if they don't do that, that's when people start getting censured for unprofessional conduct and big problems start happening, which, I mean, I'm not saying prosecutors don't lie. Generally speaking, though, they're good humans too, and they're trying to do a good job and protect the people, and they're trying to put scumbags behind bars, and they're trying to keep good people out of trouble. And, that's why a lot of times you'll see, like, if you do something and it's a little stinky, but the prosecutor goes, all right, listen, I think you were doing okay here, but you screwed this part up, and so you're going to plead to this thing, and you're going to keep your nose clean for 3 years, and then I'll forget about you. And that happens a lot. And one of the things I love about FLP is if you and your lawyer determine, hey man, I could plead to a misdemeanor here, and then this all goes away, and they go, that's between you and your lawyer. We totally understand that, and that might be your best choice. That's really important to me. And so it's when you get to the loggerheads, less than 3% of charges end up in trial, and because it's a giant pain to do. And so that's the kind of stuff where they both believe, no, we're the big monkey here and we are right. And you are going to submit to us. And that's when everything goes to heck, the proverbial heck. Heck is where you go when you don't believe in gosh. Did you know that?
Oh boy.
Yeah.
Oh boy. Bad jokes.
Oh boy.
Oh boy. Yeah. So, and testimony is always definitive to the outcomes, right? I mean, the funny part is, I believe, I don't know, the trials that I've been involved in, Mike, I'd love your experience on this, that it's not usually the facts that we're arguing about. The facts are pretty well established. We know they're coming. We know they're going to admit what they're going to admit. So the facts are well established. It's the interpretation of the facts and how the facts fit the law that we're arguing about.
Yeah, 100%. That's absolutely true. And now I'm desperately trying to think of something to add to that, except that you kind of covered it all. Yeah. And again, if God forbid your case goes to a trial, which you really don't want, if it can be avoided, trial is, you never know. As one of my favorite AUSAs told me one time, you never know what 12 licensed drivers who couldn't get out of jury duty are going to come up with at the end of the day. You just don't know. There's no way of knowing. You think you have a slam dunk, conviction case, and they're deadlocked, or they find the person not guilty or whatever. Perception, and again, simple things like, does the jury like you as a witness? Does the jury, looking over at the defense table, looking at the defendant, sizing him or her up? If you have a tattoo across your forehead that says F the cops or something, they're going to notice that. They're going to notice stuff like that. And so frequently it is the sort of intangibles that make a big difference in how a case ends up coming out in the wash. You just never know.
Yeah. All right. We got a couple more questions left. This one you guys already touched on, but it's good to just quickly touch on it again. What makes you qualified to become an expert witness?
The bar is pretty low, actually. You don't need to have this high bar. That said, the first case that I took, I was worried about it. I was like, is it going to be okay? And then I saw the qualifications of a couple of people who had been admitted in that, and I was like, oh, geez, what am I worried about? You have to have knowledge, skill, experience, education, training that qualifies you to help the trier of fact to determine the issues at stake. And so if you have that, then you can be admitted as an expert to help the court. Of course, more is more better. Nobody is ever overqualified to be admitted as an expert. I recently looked at a case, that it was a use of force case, and the guy that was the expert for the defense was literally the guy who wrote the textbook and taught criminal justice with that textbook for 25 years. So you're like, yeah, I think they got the guy in that particular case. You know, nobody's overqualified to be an expert.
All right. Another question. How do you determine if a case needs either of these things?
I think it's interesting. So almost all cases, I think, need investigators of some kind, right? So the investigator role is super, super common because if they want to find out facts or issues and those kind of things, then those are going to be needed by both sides. Now, when is an expert witness or a consulting expert needed? When there are issues at stake here that are messy, is really where it is. I never get invited to the easy ones. You know, I never get, like a woof, 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 like this is a slam dunk, super easy, piece of cake. Those never show up in my world. It's usually, so John, I got a doozy of a case for you to consider. Okay, let's talk about it. And I go, oh, that's a dog. That's not good, friend. And he goes, oh, I know, but I think I've got some stuff to work on here. Usually it's when you have to educate a finder of fact, the jury, the prosecutor, the judge. You have to educate them about how these things fit the law. And I say that as a guy that does expert witness in self-defense and firearms, right? That self-defense law is for most attorneys a 45-minute lecture in criminal law in their second year of law school. And that's it. That's all they do. Remember, law is this big thing. Criminal law is a subset of that. Self-defense law is a very small subset of criminal law. And so most attorneys have very little education about what that is. And so educating them about it, that's when you go, hey, wait a minute. No, this is okay. And so for the defense, for instance, this is okay. And this makes this all right because this is what the law says. Now, I'm going to tell you a lot of times what I'm doing is applying, here's the black letter law. Here's what words mean. Here's how all this works together. Because, of course, the law, when you look at, the law says, don't assume that law is written in English. It's not. It's written in lawyer. It sounds like English, and it uses English words, but it's actually its own language, and that language is lawyer. And so let me explain lawyer to you and translate lawyer to English, right? And isn't that crazy we have to do that, Mike?
Yeah, no, it's absolutely nuts. And again, I would encourage anyone who has the time to go watch a criminal trial in progress. And it was for me both frustrating and amusing watching the attorneys discussing, at a sidebar with a judge or when the jury's been excused, just sort of tiptoeing and just tying themselves into absolute intellectual knots, trying to figure out how to word something or what question can be asked or how it should be asked or whatever. There's so much more, and that stuff's not sexy or cool, so it doesn't make it onto Law and Order, But what John said about self-defense law is 100% true. It's just like, I'll give you an analogy. I think people think someone's a lawyer, therefore they know all the things about all the laws. That's not true. There's different kinds of law, and people can be experts in different things. Same thing holds true for investigators, for cops. I don't, if during my tenure as a law enforcement officer, if I wanted to know every part of every law, I would have to have memorized Title 8, Title 18 of the United States Code, the entire Immigration Nationality Act, the Penal Code of California, the Business and Professions Code, the Vehicle Code, the Health and Safety Code. No one can possibly know everything there is to do. So yeah, a cop will occasionally go back and sit in their car and break open a cheat book to be like, is this legal? Like, I don't even know. That bothers people. Yeah, it's 100% true. You can't possibly be expected to know everything. So with that said, normally ideally a true self-defense case doesn't get prosecuted. So generally speaking, most lawyers shouldn't have a lot of experience in self-defense cases, because if it is true self-defense and everything goes right, well then God willing, it doesn't go to trial. You don't get arrested in the first place because it was self-defense. So if the self-defense defense is valid, then most attorneys aren't going to have a ton of experience with that, which I think is part of the reason why FLP is so important, because their attorneys do have a lot of experience with this sort of thing. They know what they're doing, and you don't need John to educate an FLP attorney on anything because they already know this stuff. They're versed in it.
Yeah, I'm the guy that the FLP attorney who is well versed and well vetted in this will disclose to say, hey, we need somebody outside of me, the attorney, saying this to the jury. So
Right.
attorneys do not get to truly make points in court. Attorneys get to ask questions in court. Attorneys get to have witnesses give points to the jury. Here's a piece of evidence. Can you tell me this about that? Can you tell me that about that? What can you give to me on that? What did you see that day? What have you heard? What did you hear that time? How were those? The only time they get to make points is in their opening statement and their closing statements. Is the only time they get to tell the jury, hey, jury, I want you to see it this way. And so they don't get to just soliloquize. they get smacked down when they do that. They're like, is there a question here, or is he testifying, or what's going on here? That's what the expert gets to do, though, and to say those kinds of things. So I'm not saying I've had a case. I legit had a case where the other side, a prosecutor, let me testify about the contents of the laws of their state and didn't object. And I was like, okay, he didn't object. I'm going to answer that question. And so, that's what I get to do. So there you go.
All right. All the pre-submitted questions we went through, I think there's only one in the comments besides the little comments on getting a haircut, which you just got.
You're not going to get me to get a haircut. My wife and my mama love it. Sorry.
No.
But he just got one.
You did, right?
I did. I just got one.
I wanted to say, hey, where was it? I'm sorry. Swamp. Thank you for what you said in the comment. That's very kind. It's what we do. Thank you.
Yeah, there's a lot of really positive comments in there as well for you guys. So that was nice to see. The comment from Caleb early on saying, is there a shortage or excess of people trying to be expert witnesses in gun use of force cases?
That's hard for me to say, Caleb. I think it's a great question.
Right.
I don't know that I can answer it, though. I think there are people doing this job that, as an expert witness, that I've never heard of, that I don't know, that I've never, I've seen, who's doing that case? And then I hear it and I was like, who's that? I have no idea. So they found someone somewhere. I will say that I don't advertise now. Okay, so I can only give you my experience. I don't advertise. I don't go out drumming up business. I'm not out looking for these. I only take a couple a year because I'm so busy running the company, and well, I don't run the company. Stephanie runs the company. Please forgive me, Stephanie. I make videos for a living, and Stephanie Widener runs the company. But I'm busy doing all the teaching and all this stuff that I do for the company. And so I don't go out looking for it, and I turn down more cases than I can shake a stick at that I can take. Honestly, I took 3 in this last year. And between my wife and my work wife, we said I'm allowed 3 more in 2024. You're allowed 3 in 2024. I just accepted 1 yesterday. So guess what? I'm down to 2 more that I can take in 2024. I could do some more consulting than that, but no more actual caseload. So I don't know, Mike, you got a beat on that at all?
No, I'm wondering if maybe Caleb is considering going into this line of work, and I would encourage you to investigate it if that's why you asked the question. I honestly have no idea. I don't want to pretend like I know what I don't know. I don't know that there's a shortage or excess of people trying to do this. It's a pretty specific lane, and in my investigations usually weren't. There usually wasn't a need for that, so I wouldn't know one way or the other if it's something that was hard to find or not. But I would encourage you to look into it if something you're interested in doing, because we need more good people doing this kind of thing for sure.
Well, and if you keep up with us, we're actually I've had enough people ask me about it. Enough people are like, man, I'm really interested in what you're doing there. I wasn't aiming to do this. I just started having lawyers call me. Hey, John, what'd you think about doing this? And it scratches my itch for research writing, and it scratches my itch for justice. And especially in cases where there's video evidence, that's obviously in my wheelhouse. I'm literally the guy on that. But Carrie Dudenhofer and I are going to teach an expert witness prep class this year at some point in 2024. It's going to be 100% online, but like this kind of stuff, like live meetings, and but you're going to get to see several cases, real cases that she and I have been a part of, and work through them. And here's what we do and how we do it. And and those kinds of things. So I'm not trying to like gatekeep. I'm not trying to go like, oh, none of the rest of you people are as good as me or whatever. I got it all. No, there's probably enough to go around. And so like, if you want to do this kind of work, hey, I think once you see somewhat what the work is, the incredible flexible inflexibility, and the vagaries of court and the judge saying, I know you said you were going to testify next Wednesday, but actually you're going to testify this Tuesday. And so I need you to get on an airplane today. And you're like, Your Honor, I can't get on an airplane today. And you're like, actually, no, you are. That's a subpoena, friend. And so you're going to get your butt on an airplane today. And you're like, okay, here I come. And that's the way life is. Or this trial's been scheduled here for forever, and so you booked everything out of your life. And then, we moved it 3 weeks down the road. Well, wait a minute, I got a big national thing there. Sorry, man, you got to make yourself available. And so it's definitely got downsides. But I think it's kind of cool too.
Definitely. I didn't see any other questions that came through in the comments, just a lot of talking back and forth. But are there any last comments that you guys have before I wrap it up?
Appreciate everybody that came, man. Great discussion, good comments. Thank you. And Ariana, really appreciate you. Really appreciate you having us on. And Mike, man, you are a handsome devil and also a wealth of knowledge. Thank you, friend.
Both of those statements are accurate. Yes, I agree, 100%.
Perfect. Well, thank you guys again for joining this month's webinar. If any of you guys have any additional questions, just email us, marketing@firearmslegal.com. And in the comments, I put info@firearmslegal.com, so you can always just click there, email us with any questions. But thank you all again for joining. Remember to click the links in the caption below to sign up for your protection and use ASP now for a discounted rate. And also, there's another link down there, and it's just to let us know what you would like to see in our future webinars, because we always appreciate hearing from you, and we want to know and make sure to keep providing content that you want to watch. So remember, ASP this week has a seminar this Thursday over spiritual fitness, I believe, right?
Yeah, we talk about that on our channel all the time and how that applies. And there are 5 fitnesses. We talk about that all the time. So this week we're doing that, and that's included for all FLP members. We'd love to have you all there.
Definitely. You just said what I was about to say. So
sorry, I didn't mean to.
No, perfect. But thanks again, everyone, for joining tonight. Have a great rest of your night. Remember, protect yourself. We'll protect you.